Hello and welcome to the Minimum Competence episode for Tuesday, October 14th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover UK diesel emissions lawsuits, a $199.5 million Visa-Mastercard settlement, sanctions for lawyers using fake AI-generated citations, and my column on the intersection between tax sales and the takings clause. Let's remember, fascism is cured by reading and racism is cured by traveling. And read today's legal news. On this day in legal history, October 14th, 1911, Supreme Court Justice John Marshall Harlan I died, closing the chapter on one of the court's most powerful voices of dissent. Appointed in 1877 by President Rutherford B. Harlan served for 34 years and left an indelible mark on constitutional law, not through majority opinions, but through unwavering dissents that often read as moral indictments of the court's direction. Most famously, Harlan stood alone in Plessy v. Ferguson in 1896, rejecting the court's embrace of the separate but equal doctrine and warning that the Constitution is colorblind. At a time when the legal system was ratifying segregation, Harlan insisted that racial classifications violated both the spirit and letter of the 14th Amendment. His lone dissent, widely criticized at the time, would later become foundational to the court's reversal in Brown v. Board of Education more than half a century later. But Harlan's commitment to constitutional principles extended beyond race. He defended civil liberties in United States v. E.C. Nightco, supported expansive readings of the 13th and 14th Amendments, and warned against unchecked corporate power. His approach was rooted in a belief that the Reconstruction Amendments were designed not just to end slavery, but to secure full legal equality. Though his views often put him in the minority, time has proven Harlan prophetic. His jurisprudence helped shift the constitutional center of gravity in the 20th century as future courts took up the causes he championed alone. Remarkably, his grandson, John Marshall Harlan II, would go on to sit on the court as well, carving out his own legacy in cases like Katz v. United States and Reynolds v. Sims. Justice Harlan I's death marked the loss of a constitutional conscience, one that held firm against the tide of his era. His dissents remain a blueprint for principled judging, reminding us that sometimes the most enduring legal influence comes not from prevailing, but from refusing to go along. In a massive trial that began this week in London's High Court, over 1.6 million claimants are suing several major car makers, including Mercedes-Benz, Ford, Nissan, Renault, Peugeot, and Citroën, over allegations that they used illegal defeat devices to cheat diesel emissions tests. The lawsuit, one of the largest in UK legal history, follows in the wake of Volkswagen's 2015 Dieselgate scandal and targets vehicles manufactured between 2012 and 2017. Claimants argue that these manufacturers deliberately programmed cars to meet legal nitrogen oxide or NOx emissions standards only under lab testing, while on-the-road emissions were allegedly up to 12 times higher. This harms the environment and misleads consumers. They seek compensation for what they claim was a systemic, industry-wide choice to cheat rather than to comply with the law. The defendants deny any wrongdoing, rejecting comparisons to Volkswagen and maintaining that emission systems are legally and justifiably calibrated to function differently under certain conditions for technical and safety reasons. A central point of contention is whether the sample vehicles in the case contain prohibited defeat devices. The trial currently focuses on 20 vehicles, but its outcome will set a precedent for nearly 850,000 claims and influence another 800,000 similar suits against other car makers, including Vauxhall, Opel, and BMW. The court's decision on liability is expected by mid-2026, with damages to be determined separately. Visa and Mastercard have agreed to a $199.5 million settlement to resolve a class action brought by merchants who allege the companies colluded to shift fraud-related costs onto businesses. Filed in federal court in Brooklyn, the settlement, still awaiting judicial approval, stems from a lawsuit first initiated in 2016, challenging rule changes that made merchants liable for chargebacks when they hadn't upgraded to chip-enabled point-of-sale systems. The plaintiffs argued this policy shift violated antitrust laws, claiming Visa and Mastercard moved in parallel to implement changes that benefited the networks while leaving merchants exposed to fraud losses without any offsetting fee reductions. According to the proposed agreement, Visa will pay $119.7 million and Mastercard will contribute $79.8 million. Discover and American Express, also named in the litigation, previously agreed to a $32.2 million settlement. While all four companies deny wrongdoing, plaintiffs' lawyers praised the deal, saying it recovers around 13% of the best-case damages scenario and over half of a more conservative estimate. Mastercard stated the settlement supports its broader efforts to increase security through technological upgrades, while Visa and the plaintiffs' counsel did not comment. This case is separate from the larger $5 billion settlement Visa and Mastercard reached in 2019 over allegations of fixing credit card and debit card fees. Federal courts in California and Alabama recently fined two attorneys thousands of dollars for submitting legal filings that contained fake case citations generated by AI. These sanctions highlight a persistent problem. Despite repeated warnings and lots of reporting, some lawyers continue to rely uncritically on generative AI tools that produce fictitious case law, a phenomenon known as hallucination. Judges in both cases criticized the attorneys for failing to verify the AI-generated content, calling the misconduct more serious than simple oversight. In Alabama, Judge Terry F. Moorer imposed a $5,000 sanction on James A. Johnson, a court-appointed criminal defense attorney, who filed a motion containing fabricated citations. The judge noted that Johnson used a Microsoft Word plugin called Ghostwriter Legal and submitted the motion during a holiday weekend while caring for a relative, but emphasized that such explanations do not excuse the lack of basic diligence. Johnson must now disclose the sanctions order in all cases he handles for the next year, and his client, visibly upset in court, requested new counsel, delaying the case. In California, Judge Araceli Martinez Alguin fined attorney Edward A. Quesada $1,000 after his civil filing contained at least 3 false citations. Quesada admitted he had run out of time and may have accidentally copied one fake citation from an AI-generated web summary. He was also ordered to complete a CLE course on responsible AI use, with the judge citing his failure to stay informed about relevant legal technologies as a violation of professional conduct rules. And in my column for Bloomberg this week, I examined the property rights implications at the heart of Pung v. Isabella County, a case the U.S. Supreme Court has agreed to hear. I argue that when the government seizes and sells property for unpaid property taxes, just compensation shouldn't be defined by whatever price the property fetches at a government-run auction. That process, entirely designed and controlled by local officials, often prioritizes administrative efficiency over fair market value, turning tax sales into what I describe as a clearance rack event. The problem is structural. Local treasurers are incentivized to close the books quickly rather than ensure former owners recover equity. That means the government may undersell a home, pay itself the back taxes, and call it a day, leaving the former owner uncompensated for the true value of what they lost. Worse, when courts treat the auction price as constitutionally adequate, they allow the taker to set the value of what it took. I draw a comparison to Tyler v. Hennepin County, where the court ruled the government can't pocket surplus proceeds from a tax sale. Pung asks the natural follow-up: what rules apply when determining how much surplus actually exists? If courts accept fire sale auction prices as just compensation, they effectively endorse an end run around the Fifth Amendment takings clause. As a compromise, I propose a clear rule. Auction prices should only be presumed fair if they fall within 10% of an appraised value. Outside that range, the burden should shift to the government to prove the sale was legitimate. After all, if local governments want the legitimacy of a market sale, they need to run a sale that looks like one. Otherwise, taxpayers are left holding the bag, punished not for failing to pay taxes, but for the government's indifference to recovering real value from their property. And with that, as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here tomorrow, and until then, remember, you don't reason with a tiger when your head is in its mouth.